3 men convicted for the murder of an unarmed black man, just 25, chased down, shot, and killed while jogging.
Baby Justice Rees was born. He had methamphetamine in his system the day before he was born.
This defendant is guilty of abuse and murder because healthy 6-year-olds just die.
In May 2023, a quiet Albany neighborhood was shaken by fire that erupted outside the village barber and beauty shop. Inside, 47-year-old barber Tyrone Staley was fatally shot, while 2 others sustained minor wounds. The shooting was part of a drive-by attack that left the community devastated and demanding justice. Investigators quickly linked the crime to several suspects, including 21-year-old Samir Princeton and 20-year-old Dejounne Smith, who were later arrested and charged. Prosecutors alleged that the 2 men, along with others, conspired to carry out the deadly shooting. Albany County District Attorney Lee Kindlon addressed the case publicly.
It's dedicated to leaving no stone unturned, and between the investigation of my office and just getting ready for trial, some new stuff came to light, and we thought it was important to follow that up with a superseding indictment. Now with this trial, we're essentially starting over. We have to do motions and have hearings again, but we thought the cost of that was well worth what ultimately might be the outcome.
Friends and customers of Tyrone Staley later gathered at his barbershop to honor him. They described him as a kind and generous man.
He will certainly be missed by so many, because Ty was a very nice guy. He was kind-hearted. He didn't mind. We do a lot of free haircuts here. People don't know that. We watched a good man die.
By September 2025, the case returned to Albany County Court with upgraded charges of first-degree conspiracy and attempted murder, alongside second-degree murder and weapons possession. Both Princeton and Smith stood before the judge and entered not guilty pleas. Another suspect, Timur Miller, had already pleaded guilty to manslaughter for his involvement in the shooting and was sentenced to 25 years in prison. A fourth suspect, a juvenile at the time of shooting, remains unnamed. Both Princeton and Smith remain in custody as the case moves toward trial. In August 2018, 19-year-old Kiera Bergman vanished from her Phoenix apartment without a trace. For nearly a month, her family searched desperately, holding on to hope that she would come home. Then, on September 3, 2018, that hope was shattered. Investigators found Kiera's body off a highway in Buckeye, Arizona, ending weeks of uncertainty and beginning a long road to justice. Soon after the discovery, police named her boyfriend, John Christopher Clark, as the prime suspect. The two had met the year before on a dating app while Kiera was living in San Diego. Despite her parents' concerns, their relationship grew serious, and they eventually moved to Arizona together. On August 4th, the day Kiera disappeared, Clark told police she had walked out after an argument and never returned. But investigators soon found inconsistencies in his story. He was arrested shortly after her disappearance on unrelated charges of forgery and identity theft. Just before that arrest, Clark contacted local reporters, claiming his innocence and insisting, "I love Kiera with all my heart and would never hurt her." Police, however, said they had enough probable cause to believe otherwise. Kiera's parents, Chris and Kirsten Bergman, were heartbroken but not surprised when the arrest came. Her mother broke down, recalling how their daughter had changed after meeting him.
This is like the worst nightmare with myself. Like, what could I have said or done differently to maybe, change her mind on being with him? So now we just need to find out why he did it and how he did it.
Her father said that Clark was very controlling.
If you would ask Kiera a question, he would answer and not allow her to answer.
After the discovery of her body, John Christopher Clark appeared in Maricopa County Superior Court.
May I have your full name?
John Christopher Marcus Clark.
You are here on 1-count murder in the first degree.
Clark was charged with first-degree murder, improper removal of a body, and tampering with evidence. He appeared before a judge at the 4th Avenue Jail, where his bond was set at $1 million cash. As of the last update, the Maricopa County Medical Examiner listed the cause and manner of Kiera's death as still under investigation. In December 2015, chaos unfolded on the Las Vegas Strip when a woman named Lakeisha Holloway drove her car onto a crowded sidewalk near the Paris Las Vegas Hotel and Planet Hollywood. Her daughter was in the back seat as she struck pedestrians walking along the famous boulevard. The crash killed 32-year-old Jessica Valenzuela from Arizona and injured nearly 40 others. Witnesses described a horrifying scene as Holloway drove onto the sidewalk multiple times, hitting groups of people before speeding away. Police later found her car parked at a nearby hotel where she was calmly waiting to be arrested. In interviews years later, Holloway claimed she had blacked out while driving.
All I remember is a body my windshield.
But according to the investigators, evidence showed the act was intentional. She was charged with murder, attempted murder, and battery with a deadly weapon. Over the years, the case moved slowly through the courts. Holloway initially pleaded not guilty, but in 2025, after almost a decade of legal back and forth, she agreed to a plea deal, admitting to second-degree murder and battery with a deadly weapon. Before sentencing, another delay emerged. Holloway sent a letter to Judge Tiara Jones asking to dismiss her attorney. She said she felt she wasn't being fairly represented and wanted a new lawyer before her sentencing could proceed.
You can either represent yourself or you have to have a lawyer. I want you to understand this new attorney is going to be appointed for the limited purpose of looking at what was discussed in the letter.
Judge Jones granted her request, which means sentencing will be postponed again. After 10 years, victims and families must wait a few more weeks to hear her punishment. In February 2015, a heartbreaking case unfolded in Micciolo County, California. Justice Rees was found lifeless near a cold slough outside Knight's Landing. His mother, Samantha Green, had been reported missing and was later discovered nearby. Distraught and disoriented, investigators learned that she had taken her son out into the chilly night while under the influence of methamphetamine. The exact cause of was determined to be exposure to the cold, but what led up to that moment became the focus of a long and painful legal battle. Justice had been born with meth in his system. Child Protective Services had flagged concerns about the parent's drug use, but after promises of sobriety, the boy was allowed to go home with Samantha and his father, Frank Rees. Both parents had struggled with addiction, yet appeared cooperative with authorities. For a short time, things seemed calm. Then, only weeks after his birth, tragedy struck. Samantha later claimed she had been searching for Frank near the river when she passed out and awoke to find her son unresponsive beside her. Authorities arrested Samantha shortly after, initially charging her with involuntary manslaughter and child endangerment.
I'm happy for my daughter. Like I said, there was no murder here. So involuntary manslaughter I can live with, but murder, she didn't murder my grandson.
As the investigation progressed, prosecutors elevated the charge to second-degree murder, arguing that her actions, combined with drug use, had shown reckless disregard for her son's safety.
I saw her about a week before this all happened. She showed me the baby. I met the baby. Everything was fine. She didn't seem distraught or anything. We talked about how cute he was.
The defense maintained that it was a tragic accident, not an intentional act. Frank Rees denied knowing that Green had tested positive for drugs and claimed he was not informed of her condition.
I didn't even know that she was testing positive because they would take her in the room and say that they need to talk to her alone. You know what I mean? And I thought that was normal. If a baby's born with meth in the system, you need to take them. Period.
During the early hearings, Samantha appeared visibly emotional, at times struggling to hold back tears. Her family expressed heartbreak, but insisted she had never meant to harm him.
Count one of the information, guilty.
In September 2016, a Micciolo County jury found Samantha Green guilty of second-degree murder.
We all know it's Frank Rees. He's a loser. He's just as responsible for that baby. He should have been protecting that baby. And as a man, he should have been protecting my daughter.
Well, actually, we tried very hard not to talk about Frank Rees because Frank Rees wasn't on trial. We had a lot of opinions, but we tried to keep those off of this because he was not the one on trial here.
It didn't come up that there should be two defendants. We were very critical in the fact that Frank Rees is not on trial. He is not the one that's being charged. Samantha Green was. And we made our decision solely on Samantha Green.
Jurors said the evidence made the decision clear. They had tried not to focus on Frank Rees, who was not on trial at the time, despite claims that he had contributed to the circumstances through his own behavior. 3 months later, in December 2016, Samantha Green was sentenced to 15 years to life. The judge denied her request for a new trial, stating that her actions had endangered the most vulnerable life imaginable. Her defense argued she was a young mother caught in the spiral of addiction, but the court held her responsible for the death of her son. 2 years later, in 2017, the case resurfaced when the Micciolo County District Attorney announced the arrest of Frank Rees. Authorities said the investigation had never truly closed. New evidence connected him to the tragedy, possibly involving the administration of drugs to Samantha or to justice.
I think that the investigation of Mr. Rees never stopped. Now that could be anything from the mother providing information that links him to the crime, or it could be other independent witnesses, or it could be some physical evidence. So did he inject the mother, which caused her to be in a position where she couldn't safely care for the child? Or did he inject the child? We don't know.
Rees was charged with involuntary manslaughter, child endangerment, and administering a controlled substance. Prosecutors suggested that by enabling or supplying meth to Samantha, he had directly contributed to his son's death.
When baby Justice Rees was born, he had methamphetamine in his system. due to Samantha Green's ingestion of methamphetamine during pregnancy, including the day before he was born. Samantha Green had been living with the baby's biological father, Frank Rees. Evidence presented at trial established that Frank Rees was directly administering methamphetamine to Samantha Green despite the circumstances of baby Justice's birth.
Frank Rees eventually entered a no-contest plea, accepting responsibility for his role. He was sentenced to 6 years in prison. The development brought mixed emotions, some relief that the full story was acknowledged, but renewed grief for a family that had already lost so much. On a quiet Sunday afternoon, February 23, 2020, the 25-year-old Ahmaud Arbery went out for a jog in the Satilla Shores neighborhood near Brunswick, Georgia. As he passed through the area, security cameras captured him briefly entering a home under construction, looking around for a moment before leaving. Nothing was stolen or damaged, and the homeowner later confirmed that multiple people, men, women, had previously wandered through the unfinished property without incident. Moments later, Gregory McMichael, a retired investigator, spotted Arbery running past his house and believed he matched the description of someone seen near the construction site days earlier. He called out to his son, Travis McMichael, and the two decided to follow Arbery in their pickup truck. Both took their weapons. A neighbor, William Roddy Bryan, saw the pursuit and joined in with his own truck, later recording what unfolded on his cell phone.
I hollered at them, I said, "Y'all got him?" They got down to the end down there somewhere. I must have passed him because I pulled out of my driveway. Was going to try to block him.
The three men followed Arbery through the neighborhood for several minutes, trying to stop and question him. When Arbery continued running, the situation escalated. A brief confrontation occurred near the end of the street, where Travis McMichael fired his weapon and Arbery collapsed. Emergency crews arrived soon after, but he could not be revived. At first, no arrests were made. Body cam footage showed the father and son after the shooting.
I run in the house, I said, "Travis, the same guy that broke in the house down there."
Who's Travis?
My son, the guy that shot him.
Okay.
I said, "Come on, let's go."
We run out to stop him to talk to him. He took off running. He never did. Stopped. He come out of the truck running at us. I told him stop till he hit me. I had nothing to do. There's nothing else I can do.
Do you have any other weapons or anything on you?
Just that.
Okay.
If he would have stopped, this wouldn't happen.
That's fine. That's fine. Like I said, just take a breath. Okay.
I want it done right.
I got you. So.
This just doesn't look good. I mean, it just shot me. Last thing I've ever done want to do in my life.
Local authorities treated the case as a possible act of self-defense, and the investigation stalled for more than 2 months. However, when Bryan's cell phone video was made public in May 2020, showing parts of the chase and the final moments, it sparked national outrage and protests across the United States. Within 48 hours of the video's release, the Georgia Bureau of Investigation arrested Gregory and Travis McMichael on charges of murder and aggravated assault. Bryan was arrested 2 weeks later for his role in the pursuit.
We have amassed witnesses, documents, videotape that tells a very different story.
In November 2021, after a 3-week trial, a Georgia jury found all 3 men guilty.
First verdict form I have is the state of Georgia versus Travis McMichael. Mr. McMichael, please stand. Verdict is as follows. In the Superior Court of Glenn County, state of Georgia, the state of Georgia versus Travis McMichael, case number CR 000433. Jury verdict form. Count 1, malice murder. We, the jury, find the defendant, Travis McMichael, guilty. I'm going to ask that whoever just made an outburst be removed from the court, please. As this court has indicated, I ask that there be no outbursts in the court, and I expect as much from the gallery. Please respect the court's desire for this as we move forward. If you feel like you need to make a comment or otherwise demonstrate with respect to the verdict, I do ask that you step out of the courtroom now. Count 2, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 3, felony murder. We, the jury, find the defendant Travis McMichael guilty. Count 4, felony murder. We, the jury, find the defendant Travis McMichael guilty. Count 5, felony murder. We, the jury, find the defendant Travis McMichael guilty. Count 6, aggravated assault. We, the jury, find the defendant Travis McMichael guilty. Count 7, aggravated assault. We, the jury, find the defendant Travis McMichael guilty. Count 8, false imprisonment. We, the jury, find the defendant Travis McMichael guilty. Count 9, criminal attempt to commit a felony. We, the jury, find the defendant Travis McMichael guilty. Dated this 24th day of November, 2021, signed by the foreperson. Have a seat. As to Gregory McMichael, in the Superior Court of Glynn County, the state of Georgia versus Greg McMichael, case number CR20000433. Jury verdict form. Count 1, malice murder. We, the jury, find the defendant Greg McMichael not guilty. Count 2, felony murder. We, the jury, find the defendant Greg McMichael guilty. Count 3, felony murder. We, the jury, find the defendant Greg McMichael guilty. Count 4, felony murder. We, the jury, find the defendant Greg McMichael guilty. Count 5, felony murder. We, the jury, find the defendant Greg McMichael guilty. Count 6, aggravated assault. We, the jury, find the defendant Greg McMichael guilty. Count 7, aggravated assault. We, the jury, find the defendant Greg McMichael guilty. Count 8, false imprisonment. We, the jury, find the defendant Greg McMichael guilty. Count 9, criminal attempt to commit a felony. We, the jury, find the defendant Greg McMichael guilty. This 24th day of November, 2021, signed by the foreperson. As to William R. Bryan, in the Superior Court of Glynn County, state of Georgia versus William R. Bryan, case number CR20000433. Jury verdict form. Count 1, malice murder. We, the jury, find the defendant William R. Bryan not guilty. Count 2, felony murder. We, the jury, find the defendant William R. Bryan not guilty. Count 3, felony murder. We, the jury, find the defendant William R. Bryan guilty. Count 4, felony murder. We, the jury, find the defendant William R. Bryan guilty. Count 5, felony murder. We, the jury, find the defendant William R. Bryan guilty. Count 6, aggravated assault. We, the jury, find the defendant William R. Bryan not guilty. Count 7, aggravated assault. We, the jury, find the defendant William R. Bryan guilty. Count 8, false imprisonment. We, the jury, find the defendant William R. Bryan guilty. Count 9, criminal attempt to commit a felony. We, the jury, find the defendant William R. Bryan guilty. Signed this 24th day of November by the foreperson.
Travis McMichael was convicted of malice murder, his father Gregory of felony murder, and William Bryan of felony murder and false imprisonment. During sentencing on January 7, 2022, Judge Timothy Walmsley spoke emotionally about the tragedy, describing how Arbery had been running for his life.
Ahmaud Arbery was murdered. It's a tragedy. It's a tragedy on many, many levels. On February 23rd of 2020, almost 2 years ago, a resident of Glynn County, a graduate of Brunswick High, a son, a brother, a young man with dreams, was gunned down in this community. As we understand it, he left his home apparently to go for a run, and he ended up running for his life. He entered the English home at approximately 1:04 p.m. and left that home at about 1:08 on that day. At 1:14, Greg McMichael calls 911 to let them know that there's a black male running down the street. And within moments, Ahmaud Arbery is shot and killed. The three men that are now before this court chased him in a residential neighborhood for at least 5 minutes in pickup trucks, armed with a shotgun and a .357 revolver. The state mentioned this today about the time period, but I do want to put that time period in context. And the only way I could think to do so may be a little theatrical, but I think it's appropriate. I want us all to get a concept of time. And so what I'm going to do is I'm going to sit silently for 1 minute. And that 1 minute represents a fraction of the time that Ahmaud Arbery was running in Satilla Shores. Those circumstances, including but not limited to all aspects of the crimes charged, the past criminal record or lack thereof of the defendants. I've also considered any lawful evidence which tends to show the motive of the defendants, their lack of remorse, their general moral character, and any predisposition to commit other crimes. Now, I think in this case, the record speaks for itself, and the defendant's own words, I think, guide this court with regard to sentencing. Went back through my notes and other resources to pull some of the quotes that we have in this case. I'll start with Greg McMichael. In my opinion, Greg McMichael very early on in this tried to establish a narrative. He made comments like, Ahmaud Arbery was trapped like a rat. Stop or I'll blow your, and I won't repeat it again, head off. He effectively admitted that he wasn't sure what Ahmaud Arbery had done wrong. Quote, I don't think the guy has actually stolen anything out there, or if he did, it was early in the process. But he keeps going back over and over again into this damn house. Again, back to the narrative. Told Travis, you have no choice. Told another individual at the scene, this guy ain't no shuffler. This guy's an asshole. Commented that he wanted him, Ahmaud Arbery, to know that we weren't playing. If I could have gotten a shot at the guy, I would have shot him. Travis McMichael claims he was in shock. But it's interesting because he talks about his concern for his child and his own well-being. Part of this was while the victim was actually laying there in the street. Commented, this is the worst day of my life. Well, I think it's been touched on here today. There were other individuals that were impacted. I look at the video of this incident. When I say the video, I think everybody knows what we're talking about, but there was one part of it that struck me as absolutely chilling, and that is, I believe it's in the enhanced video provided by the GBI. There's a frame where I believe Ahmaud Arbery, it looks to be, if he's 20 yards out, that may be close, 30 yards out. And it's the frame of Travis McMichael lifting the shot to fire at Ahmaud Arbery. And you watch that with context. And when I say context, after hearing the evidence in this case, again, thinking about a young man that had been running at that point for almost 5 minutes, and it is a chilling, truly disturbing scene. And we got there because Travis McMichael's father saw Ahmaud Arbery hauling down the street and calls out, let's go. At that point, Travis McMichael, despite whatever may have been going on in his life at that time, with regard to family or otherwise, just goes, grabs a shotgun and goes because he assumes that it is the right thing to do. Ahmaud Arbery was then hunted down and shot. And he was killed because individuals here in this courtroom took the law into their own hands. Mr. Bryan, he joined in after calling out to the McMichaels. Y'all got him? Claimed he didn't know what was going on, but obviously wanted to know if this individual who was running through the neighborhood, who he didn't know, had been caught in some way. Said, quote, I figured he'd done something wrong, but I didn't know for sure. All right, that wasn't actually the quote. Those quotes are two separate quotes. Didn't know for sure. I thought he would get away. And this is the part that is disturbing to me with Roddy Bryan. If the guy would have stopped, this would have never happened. All of these quotes give context, I think, to the video that we saw during the case. And Miss Wanda Cooper-Jones this morning made a statement that I think, when you look at these statements and you see the videos, is very true. And that is, she said, when they could not scare or intimidate him, they killed him. There's been discussion about remorse. And I agree with counsel that it is dangerous for defendants who have multiple prosecutions against them to make statements of remorse. But remorse isn't something that is simply a statement of regret. Remorse, I think, can be determined by looking at somebody's reaction to difficult circumstances and the reality of the situation that they're in. Again, it doesn't require an apology, and quite honestly, sometimes apologies are made simply to get past problems. Remorse is something that's felt and demonstrated. In this case, getting back to the video, again, after Ahmaud Arbery fell, the McMichaels turned their backs. It's, again, a disturbing image, and they walked away. This was a killing. It was callous.
The judge concluded that the McMichaels had acted out of unjustified suspicion, taking the law into their own hands.
I think ultimately, with regard to the murder of Ahmaud Arbery, it holds us all accountable. I've read somewhere, and I don't remember where it was, that at a minimum, Ahmaud Arbery's death should force us to consider expanding our definition of what a neighbor may be and how we treat them. I argue that maybe a neighbor is more than the people who just own property around your house. I also believe that in assuming the worst in others, we show our worst character. Assuming the best in others is always the best course of action. And maybe those are the grand lessons from this case. I will let others spend as much time as they want writing about it and talking about it. But those are my general thoughts with regard to this case and sentencing. That said, with regard to the sentence in this case, as to Travis McMichael, Mr. McMichael, the court sentences you as follows. Count 1, malice murder, life without the possibility of parole. Count 2, felony murder, is vacated by operation of law. Count 3, felony murder, vacated by operation of law. Count 4, felony murder, vacated by operation of law. Count 5, felony murder, vacated by operation of law. Count 6, aggravated assault, merges into count 1. Count 7, aggravated assault. The court sentences the defendant to 20 years consecutive to count 1. Count 8, false imprisonment, merges into count 1. Count 9, attempted false imprisonment, 5 years concurrent to count 7. That is life plus 20. Greg McMichael, the court sentences you as follows. Count 1, malice murder, defendant was found not guilty. Count 2, felony murder, life without the possibility of parole. Count 3, felony murder, vacated. When I say vacated, it's vacated by operation of law in all cases. I'm not going to repeat it. Count 4, vacated. Count 5, vacated. Count 6 merges into count 2. Count 7, aggravated assault, 20 years consecutive to count 2. Count 8, 10 years concurrent to count 7. Count 9, 5 years concurrent to count 7. That is life plus 20 years. Roddy Bryan, I do want to separate a little bit because the state is making a different recommendation And despite the back and forth that Mr. Goff and I had during this case, I do want to point out a couple things that he raised that I think are appropriate to raise with regard to the sentence. As far as the remorse, I think Roddy Bryan stands in very different shoes. It is obvious from the beginning that he questioned the tragedy that had occurred at the scene. It was on, I believe, I can't remember whose body cam, but the body cam, in fact, questioning whether or not what had occurred, and then took steps early on in this process, I think, that demonstrated that he had grave concerns that what had occurred should not have occurred. And I think that does make Mr. Bryan's situation a little bit different. However, Mr. Bryan has been convicted of felony murder. And I do not believe it can be disputed based on the facts of this case that the verdict was an appropriate verdict based upon the evidence presented, at least. And when I say appropriate, what I mean is legal. Because I believe there's been some discussion about some differences between Mr. Bryan and the McMichaels. There may be some differences, but it does not change the fact that was it not for the fact that Mr. Bryan used his vehicle in a way to impede Mr. Arbery's course of travel, this may not have ever occurred, and that is sufficient for felony murder. He did cooperate with law enforcement. I will point out Mr. Goff, 1710-1B, there's actually a case out of Chatham County that says it would not apply under the circumstances of this case. So the court, recognizing that Mr. Bryan's position is different, again, Mr. Bryan was found not guilty on count 1 and count 2. The court sentences Mr. Bryan to life with the possibility of parole on count 3. Count 4 is vacated. Count 5 is vacated. Count 6, the defendant was found not guilty. Count 7 merges into count 3. The defendant is sentenced to 10 years consecutive to count 3 on count 8 and 5 years concurrent with count 8. Both of those counts, though, will be suspended sentences, which gives Mr. Bryan a life with the possibility of parole sentence. Those are the sentences. The court having pronounced sentence, first with regard to Travis McMichael. Mr. McMichael, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. And just to be clear on the record, I'm going to go through the statement with regard to each defendant. So as to Gregory McMichael, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury. And if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate...
He sentenced Travis and Gregory McMichael to life in prison without the possibility of parole, and William Roddy Bryan to life with the possibility of parole. Bryan, already in his 50s, would not be eligible until his 80s. The case didn't end there. In early 2021, Corey Micciolo divided his time between his mother, Brianna, and his father, Christopher Gregor, in New Jersey. Corey was described as cheerful, curious, and full of energy, a boy who loved playing outside and learning about the solar system.
What is the fifth planet from the sun? It is big. It is made of gas. It is Jupiter.
Behind the scenes, his parents were in conflict over his well-being, and Brianna had repeatedly voiced concerns about the time Corey spent with his father. In mid-March 2021, Gregor and Corey were seen together at a gym inside Gregor's apartment complex. Security footage later shown in court revealed a troubling scene. Corey struggling to keep up on a treadmill while his father stood beside him, occasionally adjusting the speed. Each time the boy slipped or slowed down, Gregor appeared to insist that he keep running. Prosecutors later said this moment reflected an unhealthy and dangerous pattern of behavior, though Gregor's defense claimed he had been simply trying to help his son exercise. Over the next several days, Corey's mother noticed bruising on her son's body. She told investigators she had contacted authorities and welfare agencies, expressing fear that something was wrong. Her concerns were noted, but no immediate action was taken.
Because that happened a few times. Like, that video wasn't the first time it happened.
What did you see?
He had, like, you know, if someone were to grab you, he had them on his arms, like fingerprint bruises. He had bruises on his forehead. He's had black eyes. I would ask him how he got it, and he was so afraid. He most of the time he wouldn't tell me what happened. And whatever lie his father told him to say is what he would say to me. I think he hated me because I didn't get he didn't want to be a dad. I think it kind of was like forced on him by his family. I hate him, and he took everything from me.
Did your son ever ask you to save him?
Yes, he did. And he asked me why no one was helping. So he just gave up. I just miss him. And sometimes I just want to say sorry, but I know I tried.
On April 1st, 2021, Gregor took Corey to a doctor's office. During that visit, Corey mentioned that his father had made him run on a treadmill because he was too fat. The following day, April 2nd, Gregor brought Corey to the emergency department after the boy became ill. According to hospital staff, Corey was dizzy, weak, and struggling to speak clearly. While doctors were running tests, Corey suddenly went into medical distress. Despite their efforts, he passed away later that day. An autopsy was conducted, and the results raised serious concerns. The medical examiner concluded that Corey's death resulted from injuries that had occurred within a day of his passing, along with other signs that suggested repeated harm over time. The manner of death was ruled homicide. Gregor's behavior following his son's death quickly drew scrutiny. Just 2 days later, on April 4th, police in Alcoa, Tennessee stopped him during a traffic check. Investigators later said he had left New Jersey soon after dropping Corey off at the hospital. In the body camera footage, Gregor appeared tense and emotional while officers asked questions about his travel. He blamed the boy's son for the injuries.
I knew when he got home he was cheating, and I knew something was wrong with my gut, but I just thought she had home waiting from everything that he needed sleep. And I should have took him like he was doing. There's a lot of me things like, it's partially my fault in the sense that if they truly did something, it wouldn't, like, you had a shitty life with a drug addict mother, but he'd still be alive if I never came back from Baltimore to fight for justice. And that's been going through my head this whole drive. She's special kind of dirtbag.
Prosecutors later argued that he had been fleeing the state. The defense insisted he was simply overwhelmed and visiting relatives. The video was ultimately shown outside the jury's presence, but was not entered as evidence because the judge found it overly prejudicial. In the weeks after Corey's death, detectives obtained Gregor's internet search history. Records showed several alarming entries, questions about bruising, and about how long it might take to file charges after an autopsy. These searches were made both before and after Corey's death.
A search conducted on March 25th, 2021 at 9:36:31 p.m. The body of the search states, will red marks turn into bruises? The next entry is April 2nd, 2021 at 6:10:22 p.m. The search was, can your phone be tracked in airplane mode?
The next one.
The next search was for April 2nd, 2021 at 6:10:35 p.m. for, can my car be tracked? Next search was on April 4th, 2021 at 9:58:03 a.m. The search was, there was a murder determined from an autopsy. How long to file charges?
Is there another one?
The last one is on April 4th, 2021 at 10:21:16 a.m. The search was, how long after an autopsy to file charges get filed?
Prosecutors argued that the timing of those queries revealed Gregor's awareness that something serious had happened and that he was anticipating potential legal trouble. In July 2021, Gregor was charged with child endangerment connected to the treadmill incident. After further investigation, the charges were upgraded in March 2022 to aggravated manslaughter. During the trial, prosecutors relied heavily on the gym surveillance footage and medical findings. They told jurors that Corey's death could not have been accidental, emphasizing that a healthy boy does not suddenly pass away without cause. The defense countered with a different theory. They said Corey may have died from an undiagnosed medical condition, possibly an infection that caused internal complications. They also called forensic experts to argue that the injuries might have been misinterpreted. Christopher Gregor was found guilty of aggravated manslaughter and child endangerment. He was acquitted of murder, meaning jurors did not find that he intended to cause his son's death, but held him responsible for reckless conduct that led to it. At his sentencing in August 2024, Gregor faced the court one last time. The judge imposed a 25-year prison sentence requiring that he serve at least 85% before any chance of release. In early May 2024, police were first called to Ryan Michael Bates' home in northern Utah for a domestic disturbance incident. That case resulted in several charges, including allegations of assault and property damage, and it later became part of a larger investigation. For a few months, life in Tremonton moved quietly. But on August 17, 2025, everything changed. Officers were sent to Bates' home again after another report of domestic violence. When they arrived, what should have been a routine response quickly unfolded into a dangerous situation inside the house. During the confrontation, two Tremonton police officers, Sergeant Lee Sorensen and Officer Eric Estrada, were fatally injured. A sheriff's deputy and a police K-9 were also hurt while responding. According to official statements, the situation escalated so quickly that officers had little time to react. Bates was taken into custody, and the investigation expanded immediately. Prosecutors filed a long list of charges: multiple counts of aggravated murder, attempted aggravated murder, possession of incendiary devices, possession of weapons with criminal intent, and several domestic violence-related offenses tied to the earlier May incident. Because two of the charges were capital offenses, the state of Utah formally announced that it would seek the death penalty, a decision that underscored the seriousness of the case. Prosecutors filed official notice on August 21, 2025. Bates made his first court appearance shortly afterward. He appeared from jail as the judge read each charge to him, explained his rights, and confirmed that he wanted an attorney.
Right. You're here today for your initial appearance in cases 251100, 344, and 343. I'm going to read to you the charges that have been filed against you by the state of Utah in these two cases. We'll start first with case 251100, You've been charged with count 1, attempted aggravated murder, a first-degree felony, in violation of Utah Code 76-5-202. Have a copy of the charging documents called informations there in front of you. Count 2, aggravated murder, a capital offense in violation of Utah Code annotated 76-5-202. Count 3, aggravated murder, a capital offense in violation of Utah Code annotated 76-5-202. Count 4, attempted aggravated murder, a first-degree felony in violation of Utah Code 76-5-202. Count 5, attempted aggravated murder, a first-degree felony in violation of Utah Code 76-5-202. Count 6, attempted aggravated murder, a first-degree felony in violation of Utah Code 76-5-202. Count 7, endangering a police service K-9 with conduct likely to injure or kill, a third-degree felony in violation of Utah Code 76-13-209 2C. Count 8, possession of incendiary device, a second-degree felony in violation of Utah Code 76-15-210 2A. Count 9, possession of incendiary device, a second-degree felony in violation of Utah Code 76-15-210 2A. Count 10, possession of incendiary device, a second-degree felony in violation of Utah Code 76-15-210 2A. Count 11, possession of a dangerous weapon with criminal intent, a Class A misdemeanor in violation of Utah Code 76-11-208. Count 12, possession of a dangerous weapon with criminal intent, a Class A misdemeanor in violation of Utah Code 76-11-208. Count 13, assault, domestic violence with a prior qualifying offense, a Class A misdemeanor in violation of Utah Code 76-5-102, subsection 2. Count 14, assault, domestic violence with a prior qualifying offense, Class A misdemeanor in violation of Utah Code 76-5-102, sub 2. Count 15, assault, domestic violence with a prior qualifying conviction, a Class A misdemeanor in violation of Utah Code 76-5-102, sub 2. Count 16, unlawful detention, domestic violence with a prior qualifying offense, Class A misdemeanor, in violation of Utah Code 76-5-304 2A. Count 17, threat of violence, domestic violence with a prior, a Class A misdemeanor in violation of Utah Code annotated 76-5-107. Count 18, domestic violence in the presence of a child, a Class B misdemeanor in violation of Utah Code 76-5-114, subsection 2. Count 19, domestic violence in the presence of a child, Class B misdemeanor in violation of Utah Code 76-5-114, sub 2. And count 20, domestic violence in the presence of a child, a Class B misdemeanor in violation of Utah Code 76-5-114, sub 2. In that charging document before you, there is set forth a probable cause statement, and it has the details of the allegations against you. There's also all of the alleged elements of each of the specific charges that the state has alleged against you, which is set forth in more detail on that information that is set forth in the charging document. In conjunction with case 251100344, the state of Utah has filed a notice of intent to seek the death penalty in accordance with Utah Code 76-5-202, subsection 3A. The state of Utah has filed notice, and you are hereby on notice that they are seeking the death penalty for counts 2 and 3, aggravated murder in violation of Utah Code 76-5-202. Additionally, the state has charged you in case 251100343 with the following. These allegations have a alleged offense date of May 8th, 2024. Count 1, aggravated assault, domestic violence, a third-degree felony in violation of Utah Code 76-5-103, subsection 2. Count 2, domestic violence in the presence of a child, a third-degree felony in violation of Utah Code 76-5-114 2B. Count 3, domestic violence in the presence of a child, third-degree felony in violation of Utah Code 76-5-114 2B. Count 4, domestic violence in the presence of a child, third-degree felony in violation of Utah Code 76-5-114 2B. And lastly, count 5, property damage or destruction, domestic violence with a prior qualifying conviction, Class A misdemeanor in violation of Utah Code 76-6-106.1 2B. The charging document contains a probable cause statement, and the charging document also contains each of the alleged elements for each of the 5 counts.
Because of the capital case designation, special defense attorneys qualified to handle death penalty matters were appointed. During this hearing, the judge also addressed a request for a protective order related to the earlier domestic violence case. The order restricted Bate from contacting the alleged victims involved, while still allowing defense investigators limited access for witness interviews.
The defendant does have rights under the Utah Code and the Utah and United States Constitution. He is entitled to a pretrial detention hearing where his custody status can be addressed. I understand that you do not have discovery yet, Mr. Nish. There currently is an order holding the defendant without bail. There was previously a finding by the court that this is a capital felony and there is substantial evidence to support the charge. And so he's currently being held on a no bail status. Would you like to address his custody status today, or would you like the benefit of getting discovery in the case before addressing that?
Your Honor, we'll defer addressing detention at this point. We'd like to get a copy of the discovery, have some conversations with opposing counsel. we'll let the court know when and if we'd like to set that detention hearing.
Thank you. All right. In addition to some of those other things that the court has addressed, I'm noticing that in the case stemming from alleged offenses from May 8, 2024, the prosecution has filed a request for a pretrial protective order. In that order, in that proposed order, they are seeking an order of protection that would protect the alleged victim in that case. I'll just refer to her by her initials for her privacy. That would be MS. And they are seeking an order that would protect her from any threats or acts of domestic violence, stalking, abuse. They are also listing some children that they are seeking protection from. The initials on those would be DJ, MB, and EB. They're requesting a no contact order that would prohibit the defendant from harassing, telephoning, contacting, or otherwise communicating with the protected parties. And then there's some other details about the defendant and the protective person share custody of one or more minor children. And they're requesting an order that the defendant only contact the protected person to arrange visits with children by the options below. And it says in accordance with any ruling from a family court. So essentially, it seems like the state is requesting no contact unless it's approved by the family court. There's also a request that the defendant be prohibited from living at the protected person's residence. And he could get some of his belongings from the residence potentially with appropriate protocols. He's ordered to stay. The request is that he be ordered to stay away from the protected person's residence, school, workplace, etc. And have you had a chance yet to, I know that Mr. Bushell has been appointed in that case, but for the limited purpose of today's hearing where you have been appointed in the case ending in 344, I wanted to address that. Mr. Wardle, you're here today on behalf of the state of Utah. Will you be the prosecutor on this case moving forward?
Honor, I'll be on both of the cases.
All right. Anything further that you'd like to add as far as your request? I guess perhaps we need to see if there's any objection by the defense to the court signing off on that pretrial protective order, but anything further that you would like to add?
No, I think it's contained in the protective order.
Mr. Nish?
There's something I'd like to address, Your Honor. Well, it's Mr. Bushell's case, so I got to be careful about standing here. As it comes to my case, at some point in time, and I don't know who these people are yet, I'm sure they'll be identified in discovery in some way. They are likely to become witnesses in some respect in the capital case, whether that be fact witnesses or whether they be mitigation witnesses. I don't object necessarily to the protective order, but I would like the court to add a carve out that members of my team, whether it be the attorneys, my fact investigators, or my mitigation investigators, may make contact with them for purposes of learning about our case and building our mitigation case, and that technically we would be doing so on behalf of our client as we are advocates, that not be construed as a violation. And they don't have to talk to us if they don't want to, but we need the ability to at least approach them.
Okay, so you're requesting some carve-out language to allow the attorneys and investigators on the defense team, but not the defendant himself, to be able to reach out and attempt to interview, conduct investigation, and some of these protected persons may be people that need to be interviewed or attempted to be interviewed. Mr. Wardle, your thoughts?
I mean, I understand that. I think that they have their duty and their rights to do that. And as Mr. Nish said, of course, I just want to make clear the court isn't ordering that they have to speak to them, but just that the defense counsel and their people wouldn't be, assisting in violating that order. I understand where they're coming from, and I don't object to that.
And
Yes.
my team is very professional, Your Honor. We know how to make these approaches without causing undue harm or trauma.
The judge reviewed the case background and ordered that Bate continue being held without bail, citing the severity of the charges and the existing evidence supporting the capital counts. With the defense needing time to study the large volume of evidence, both sides agreed to set the next major hearing, called a decision to preliminary hearing, for October 30th, 2025, to be held via video conference. As of now, the case remains active. Bate stays in jail with no bail status, the death penalty notice is still in effect, and the court is preparing for the next stages of hearings that will determine how the case proceeds. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.